You can get started, Courtney.
Hi, everyone. For those of you who don't know me, I'm Courtney Weiner. I am a solo practitioner focusing on consumer law, specifically consumer finance issues. So what that means in practice is that I spend a lot of my time suing banks and advising people on student loan issues. There are a lot of issues that have come up in this area in the pandemic, and a lot of emergency legislation that's been passed to deal with the economic fallout and the consumer issues that follow that. So I am going to talk a little bit about mortgages, student loans, other debt. These are things that may affect you personally. They very likely affect a lot of your clients. So I will give you an overview of what sort of protections are out there. I have gotten a couple of unstable internet notifications, so just bear with me, please, if there's any hiccups on the technology side. So hopefully you're seeing the PowerPoint as it comes up. Let me know if you're not.
Yeah, you went out.
The first thing I want to talk about is mortgages. Okay. There's a lot of protections out there on mortgages. Am I back?
You're back now.
Okay. So a lot of these mortgage protections came about during the 2008 financial crisis. And the biggest piece of legislation out there is RESPA. RESPA's been around for a while, but a lot of these protections are newer. The biggest thing that RESPA provides for consumers is the notice of error provision. And what that means is that if you look at your mortgage statement and something seems wrong, if you start getting correspondence that seems off, you have the right to send a notice of error. Like address on identifying information, your account information, and you tell them what they did wrong. And then they have about 30 days, give or take, to get back to you with some sort of resolution, either fixing it or telling you that they're not going to fix it, telling you why it's right. So that's something to just keep in the back of your head if anything seems wonky with your mortgage. If you or someone you know is facing financial difficulty and can't afford their mortgage, there's the option of loan modifications. You send in an application, they ask for a lot of different documents, and they basically rewrite the terms of your mortgage, usually to extend it and or give you a lower interest rate. There's other loss mitigation options available, such as short sales, deed in lieu of foreclosure. All of those generally require an application process, and RESPA and its enacting regulations provide a specific timeline for that. The other, The other thing that has nothing to do with any of the emergency legislation, a lot that they can do to help with the mortgage. They can give forbearances, they can give deferrals on payment to delay things. They could do fee waivers. The federal government and the states and the DMV have all done something on the mortgage issue. And just as a side note, I am admitted in DC and Maryland. I'm not admitted in Virginia, but I did some checking to see what the options are out there for those who are based in Virginia. On the federal level, the CARES Act provides a moratorium on foreclosures and evictions for federally backed mortgages through mid-May. Federally backed mortgages are those that are through Fannie or Freddie that are insured. You can tell if your mortgage is federally backed by looking for Fannie and Freddie. There's a lookup tool online, and for a lot of the others, it would be in your mortgage paperwork. For example, if it's FHA backed, there would be an FHA number on your mortgage paperwork. Also, for federally backed mortgages, you can request a forbearance for 180 days, and there's an application process. So they would need to show that you qualify, that you're facing hardship, and you can also ask for an additional 180 days without any fees or interest accruing. You do, in a forbearance, have to pay back what you would owe during those 180 days or 360 days at the end of that period, or work out a loan modification or payment plan. In DC, there's a blanket prohibition on new foreclosures and evictions. As most of you know, the courts are functionally on hold for most cases, and that applies to foreclosures as well. The DC statute provides for a 90-day deferment and waiver of fees with an application, and that covers all mortgages, not just federally backed mortgages, and in fact, it covers commercial mortgages as well. And the DC statute addresses the repayment terms. Whereas under the federal law, you could potentially have an entire year of payments. Provides that it would be, oh, I think I just went out again. DC provides that it can be payable over 5 years or before the end of the mortgage term, whichever is earlier. Notably, if someone with a mortgage gets that kind of deferment, they have to pass that on to their tenants. In Maryland, there are also no new foreclosures during the emergency. The state requires a notice of intent to foreclose, and they've stopped processing those. They've also, like DC, put existing foreclosures on hold, as well as evictions. They have provided a 90-day deferment, but without the extended payment requirement that DC has, and a waiver of late fees. Virginia, as is unfortunately the case with most most consumer issues, has a lot fewer protections, and that applies here as well, but they do have a prohibition on evictions. Before I move on to student loans, does anyone have any questions about mortgages?
Yeah, if anybody has questions, you could put it in the chat. I started a chat on the side just because it might be easier than unmuting everybody because it gets very noisy. So if you have any questions, put it on the chat and I'll alert Courtney.
Okay. So student loans. The CARES Act addresses those as well, and does some pretty good stuff for direct loans. So direct loans are basically any loan after 2010 or loans that have been consolidated to be directly through the Department of Education. Other kinds of loans that are out there are FFEL, which are older loans, and they are federally guaranteed, but they are usually held by a bank. Or Perkins loans, which are also federally guaranteed, but are held by usually the school. If those are defaulted and have made their way through the guarantee process back to the Department of Education, then these student loan protections would apply to those as well. What the CARES Act provides is that there is an automatic administrative forbearance until September 30th, 2020. That means that no payments are due. Interest will not accrue, unlike other forbearances. Borrowers don't have to ask for this. It is automatic. All collection activity by the Department of Education is also stopped. That includes garnishments and offsets. What's particularly great about how they did this is that ordinarily in a forbearance, the months that you're not paying don't count towards any forbearance, whether under an income-driven repayment plan, don't count towards any forgiveness, whether under an income-driven repayment plan or under the public service loan forgiveness program. Under this type of forbearance, they do. So you don't have to pay for 6 months, but those months still count towards your forgiveness period. For the federal loans that are not covered, FFEL and Perkins specifically, if they are not held by the Department of Education, there are still some options. They are federal loans, so there's options that are available for all federal loans. That includes an income-driven repayment plan. So if you've lost your job and your income is now zero, your payments would very likely be zero. You just have to ask to get into that plan, or if you're already in that plan, you have to ask for your payments to be recalculated based on your new income or lack thereof. Consolidation is also an option. There's certain loans that you don't want to consolidate, or at least you don't want to consolidate them with other types of federal loans, but by and large, consolidation is a good option, and it turns FFEL and Perkins loans into direct loans so that they're eligible for these sorts of considerations. Rehabilitation, if someone falls into default during this time on those loans, is an option as well. That essentially means that if you enter in a rehabilitation agreement and make 9 out of 10 months worth of payments on time, then your loan goes back into good standing. All of this is only for federal loans. Private loans are pretty much like any other debt that's out there, which means you can contact your servicer to see what options are available, and hopefully they'll work with you during this time. One big thing: never consolidate federal loans and private loans together, because you lose all the protections of federal loans. Okay. And again, let me know if you have any questions.
Can you say that one more time? Because that was pretty important.
Yes, never consolidate private loans and federal loans together. Federal loans have all sorts of protections and options, and once you consolidate them with private, they become private and you lose all of that.
Thank you.
So moving on to debt collection. This applies to any kind of debt. The laws, I think I'm losing my, there we go. I think the laws that are out there to protect against debt collection abuses apply to debts that are for personal, family, or household use. So that's pretty broad. But it doesn't apply to, for example, a second home that you are renting out, that you have just for investment purposes. The main existing protection out there is the Fair Debt Collection Practices Act on the federal level, which prohibits unfair, misleading, or abusive debt collection activity. And if anyone has any questions about that, I'm happy to go into what might constitute that. You have the right under the FDCPA to request that a debt collector cease and desist, that they can still sue you if that's the case. DC and Maryland also have consumer debt collection laws that have similar protections to the Fair Debt Collection Practices Act. DC and Maryland can apply to original creditors. The FDCPA only applies to debt collectors. So someone who's at least one step removed from the actual debt. both all of these laws can apply to lawyers who are acting as debt collectors as well. There are a number of emergency provisions that have been implemented in all three jurisdictions, DC's being the strongest. DC basically froze all debt collection during the emergency and for 60 days thereafter. That means no garnishments, no communications from debt collectors, no visits, no new lawsuits, and existing lawsuits are basically on hold. So this is something that you definitely want to be looking out for. If someone is trying to collect from a debtor in DC, they very well may be violating the law. It's unclear whether that applies to continuing with existing garnishments. I'm actually in the middle of a fight with an opposing counsel on that very point right now. But my position obviously is that it does apply to that.
Courtney, quick question.
Yes.
I'm not practicing, so I might be off with this, but would this also apply to like medical liens?
Yes.
Oh, that's interesting. Okay. That's a big topic.
Yeah. Medical debt is just like any other debt in terms of the protections of these laws.
Okay.
That falls into the family, personal, household use category. And in fact, I end up representing a lot of people whose medical debt gets passed on to a debt collector. So in Maryland, there are no specific mandates on debt collection, but the state has provided guidance. I believe it came directly from Governor Hogan, strongly encouraging debt collectors to work with debtors to mitigate the impact of the financial hardship that's happening right now. Virginia is prohibiting new garnishments through April 26th. That's I'm hopeful that would be extended, but that's what they have right now. Other kinds of debts. For credit cards, there is federal guidance out there encouraging companies to work with customers, but the customers generally have to request assistance, whether that's waiving interest, spreading out payments, skipping a payment. There's a lot of different options, but you have to call your credit card company and ask. For auto loans, DC and Maryland have prohibited repossessions during the emergency. Virginia has not. Overdraft fees and other fees relating to bank accounts. There are a lot of banks out there that are waiving them. Some are doing it automatically, but for a lot of them, you need to request the waiver. For utilities, in DC and Maryland, they have prohibited disconnection during the emergency, and that includes cable and internet as a utility. Virginia has also prohibited disconnections, but their prohibition does not cover cable and internet. Payday loans and other high interest loans are likely to be floating around a lot right now as people are desperate for some sort of cash. They're illegal in DC and Maryland. There are also usury caps in all three jurisdictions, and the specific one depends on the jurisdiction and the size of the loan. But for all of the states, there are no loans that can exceed 36% APR. There's a few exceptions to that, but that's the general rule and something to be on the lookout for if you see high interest loans. Credit reporting. The Fair Credit Reporting Act has been in place for a long time, and that has a number of different provisions, but the most relevant is that furnishers, the banks or other agencies that are providing the information to the credit bureaus, and the credit bureaus themselves cannot report inaccurate information. In order to invoke that protection, you have to file a dispute with the credit bureaus directly, not just with the furnisher of the information. And the bureaus are required to pass those disputes on to the furnishers, and both the furnisher and the bureaus have to do an investigation. The bureaus have 30 days to respond, although the CFPB has recently issued some guidance suggesting that the bureaus may get a little more time under the circumstances. The Fair Credit Reporting Act, as I said, does a number of things. One other piece that's potentially relevant here is that it is the piece that prohibits unauthorized access to your credit information. So when you're looking at your credit report, you always want to look both at who's reporting what, but also who has accessed your credit report recently. And if there's someone on there that you don't recognize or that you didn't authorize, it's definitely worth looking into further. The emergency provisions in the CARES Act address credit reporting to some extent. They definitely could have been better. But they do say that if a lender or servicer or other debt holder has agreed to an accommodation with the borrower, they have to report those borrower at the beginning of the accommodation. So if a borrower, if a borrower was current when all of this started and requests an accommodation and fulfills the terms of that accommodation, the lender has to keep reporting them as current. If they were delinquent and they request an accommodation, they will still be reported as delinquent unless during that time they become current, in which case they'll be reported as current. For the loans that are subject to the administrative forbearance for student loans, those will not be reported as late during the forbearance period.
I think you froze.
And one other very recent thing that came not from the federal government. Am I unfrozen?
You just
Can you guys hear me?
Unfrozen. Yeah.
Okay, good. So one recent thing that came from the credit bureaus themselves, and not from any legislation, is there is a legal requirement that people must have access to their credit reports for free on an annual basis, and you can go to annualcreditreport.com to get that. But the credit bureaus have agreed to provide it for free on a weekly basis for the next year. So the key takeaways: reach out to lenders and servicers for assistance. A lot of them are very willing to work with people under the circumstances, and all you really have to do is ask. Monitor your credit report. If there's something that's wrong on there, you want to get to it quickly before it becomes a problem. And if something doesn't seem right, contact a consumer attorney. What questions can I answer for people?
So we can either put your questions over in chat, or I'm going to unmute you just as everybody knows, just in case you have a question, just to know I'm going to unmute you.
Yeah, I think it's a small enough group I can.
Yeah. So does anybody, have a question? I'm unmuting you just for a moment. if anybody has a question, they can go ahead and ask now. Anybody?
Yeah, Courtney, this is Chris Zampona. Does a lawyer that has a collection against a former client, that applies to this, I assume as well, right?
For some of the provisions, if a lawyer is collecting on his own behalf, he would be covered by the DC and Maryland statutes, but not by the federal.
Okay, thank you.
Any other questions?
Hey, Courtney, this is Dan Singer.
Hi, Dan.
Hey, you can hear me?
Yep.
I was just curious.
I can.
I might have missed this, but for mortgages, I mean, are lenders requiring you to show, some effect on income in order to get some type of modification?
For a loan modification, there's the whole underwriting process, and that's a long-term change to your loan. If you're just looking for a shorter-term forbearance or deferral, I have not seen the content of the applications, but it is an application process that requires you to show some sort of hardship. Under the DC statute, there is an appeal process for that, though.
Interesting. Thank you.
Any other questions? Nope. Okay. Well, Courtney is going to do two things. We're going to have this recording available for whoever wants it, and she's also going to make this slideshow available to everybody. So much appreciate your time this afternoon, Courtney, and sharing this information with us. And I thank everybody who joined. Sorry about the internet connection. It was a little bit spotty, but that's life. That's life over Zoom. So anyway, everybody have a wonderful weekend and stay safe.
Thanks,
Bye, everyone.
everyone. for having
Thank
us.
you. Thank you, Courtney.
Take care all. Bye-bye.
Bye-bye.
Bye.